The subcommittee will come to order. Without objection, the chair is authorized to declare a recess at any time. I want to welcome everyone to today's hearing, the first hearing of the of the IP Subcommittee of the Judiciary, and intellectual property and strategic competition with China was chosen to be our first hearing, chosen not because we have exclusive jurisdiction over China, but because it was incredibly important that we look at what is now the third largest applicant for patents and an organization who has a strategic plan. As we'll hear from our witnesses today, America, the heartland of innovation, is in fact fertile ground for China's investment in our patents. American national security is at risk because of China's government's quest to achieve superiority using both internal and externally gotten technology. They will use both legal and illegal means in order to gain technology that they take to China and often use to create secondary patents, meaning steal the technology from here, patent back here again, sue then here. Our witnesses represent a broad group of experts in the area, and I believe they will both educate us and, to a certain extent, scare many of us. The fact is, we understand that China is one of our largest trading partners. China is arguably our peer in total GDP and has a growth rate that is likely to exceed ours in the coming years. Normally, that would be a good thing. Ever since Nixon went to China, we have believed that engagement with China and the growth of private enterprise and wealth of the Chinese people would in fact moderate the behavior of the Chinese Communist Party. As we'll hear from our witnesses today, not on the dealing of the Chinese Party, but on the dealing of the government relative to their desire to take from America and Europe technology for Chinese global advantage. And what is the price tag of that? To the U.S. economy, it represents anywhere from a low of $250 billion to estimates that reach or exceed $600 billion a year. That's more than the GDP of many aspiring countries. It is more than any one corporation would ever dream of making in a year, and it might in fact be low in our estimations. Entities funded by the government are also flooding the Patent and Trademark Office with dubious patent applications. In fact, not only are they dubious, but they often end up in the hands of non-practicing entities who specialize in suing U.S. firms, meaning they get the patents that are pretty useless except to sell to trolls. They sell them to trolls. Many companies are involved in this, but I'll mention today Huawei. I'll mention them because in addition to being one of the largest stealers of technology, including 5G technology, they also represent a national threat to any country that puts their products in, so much so that the United States has chosen to ban their products. We ban their products. We do not ban the revenue they receive, both directly and indirectly, from dubious patents that are filed against U.S. companies. To make matters worse, they don't just do it in Article 3 courts. They use our ITC as though they were a domestic producer in order to sue and often stop an American company from producing a product that the American company invented. It should not be surprising then that the fastest growing foreign country of origin for U.S. patents is China. It went from 4th in 2018 to 2nd in 2022, exceeding Japan and our other allies. As troubling as that sounds, it could be worse. The World Trade Organization, the WTO, with support of the Biden administration, adopted a waiver that permitted China and other nations to disregard IP rights on COVID vaccines held by American companies. That is essentially a transfer of technology to China and other countries, and I would mention China and India as the two major beneficiaries. What's more troubling is the desire to make this a regular practice of essentially, after someone has invested millions or billions, to simply set aside their patent rights. When patent rights are set aside, there is two sets of damage that can occur. The first set is the obvious, that your foreign markets disappear because the technology is available, and instead of buying your product or licensing your patent, they simply produce the competing product. But what makes matters worse is this technique also can create the seed for companies that otherwise would never be able to catch up or even pass us, and essentially put the U.S. innovator out of business by flooding the market with products that are the fruit of a patent not paid for, but given away. Many of these things would appear at times to be partisan issues. And certainly the fact that President Biden has made this decision makes it seem partisan. But let there be no doubt, many presidents of both parties have wanted to look on the world stage as though they cared more about the rest of the world than they cared about American ingenuity being properly rewarded as the Constitution requires. So although I make this point, and I will be have introduced the No Free Trips Act, I want to make it clear we expect this to be and continue to be, on this president and those that follow, a bipartisan issue, one in which members who care about domestic intellectual property production will side with making it stronger, and those who care about a global view may choose to be on the other side. I don't believe that will come out on partisan lines as much as it will come on ideological lines. Many of my best partners over my 24 years in Congress, 23 going on 24, have in fact been members on that side of the dais, and I expect that to continue to be. Unfortunately, China has learned to capitalize on developments of certain U.S. States in addition to that. Today we will touch on, to a certain extent, on non-compete agreements. I expect this will not be the only time. My home state of California has effectively made non-compete illegal. As a result, anyone who takes a job in California has a free ticket to go from California with any technology they've gained, including trade secrets, and simply go to another country with it and sell it. There are countless examples of that, including Qualcomm, Intel, and Google, and Apple, who have been the victims of technology developed, trade secrets developed, simply going to another country. And again, if they go to China, they often end up in patents that are the fruit of that otherwise unknown or developing technology. Simple antitrust or simple non-compete agreements that simply invalidate the year or two after someone leaves from being able to patent something that they learned about in their first company have been invalidated in California, and there's an effort to make that national. Let there be no doubt, we support the idea that people should be able to leave a job and go to another job. No non-compete should bar somebody from being able to continue to operate with the knowledge and training that they came in with. But there's a huge difference between a salesman going from one company to another and a salesman leaving with the price list, the customer list, and all the data, and simply moving over to another company and saying, I come with the information that I took from my company. That's easy for people to understand. It is more complicated often to understand when you have intellectual property or the knowledge that is in a nascent way, but extremely valuable. So as you can see, today's hearing, the first of many, is necessary because this, not just China, but our intellectual property is under attack, our system is under attack, and this committee is absolutely committed to both give it airing so the public understands it and do legislation to protect the American inventor. And with that, it's my pleasure to introduce my new ranking member from Georgia, Mr. Johnson, who I've worked with in the past on this committee, and I look forward to working with on these and other subjects. The gentleman is recognized.
Thank you, Mr. Chairman, and it's a pleasure to be the ranking member on the committee that you are chair of, the subcommittee. And I want to commend you for your bipartisanship as we approach the bipartisan issues of this subcommittee. I share the grave concerns of my colleagues about the Chinese government's theft of the intellectual property of our nation's innovators. We know that the scale of China's IP theft is enormous. We know that it hurts our inventors' ability to compete and succeed, and we know that we need to improve our laws and policies to not only protect America's intellectual property from the Chinese government, but also to mitigate the damage already done. The solutions to the problems resulting from the Chinese government's concerted and systematic IP theft will, no doubt, be complex. For this reason, I'm glad to hear from our panel of witnesses today, who I understand are leading experts on the relationship between China's IP theft and our national security and economy. Thank you for testifying and for sharing your knowledge on this important topic, and I plan to take to heart your testimony and suggestions for how we in Congress can ensure the continued success of our nation's innovators. In particular, I hope to hear from the witnesses how we in Congress can do more to protect the intellectual property of our nation's small businesses. Small businesses are the backbone of America's economy. They create most of our country's net new jobs. They drive our economy and are responsible for a substantial portion of our gross domestic product. Small businesses also drive innovation in our country. They are more likely to develop and bring new and disruptive technologies to market than large businesses. In my view, small businesses need strong intellectual property rights to protect their innovations. This helps not only the small businesses, but America's economy as well. Small businesses that apply for patents and other types of intellectual property protections are more likely to grow quickly, hire engineers and scientists, and succeed than those businesses that do not engage in intellectual property protection. As we learned in the last Congress, however, small businesses are struggling to protect their intellectual property. Any patent that is valuable has become subject to repeated attacks at the Patent Trial and Appeal Board, often by actors who have no substantial monetary or public interest in the underlying technology. Their game is to drive small businesses into bankruptcy, as few small businesses have the financial backing to survive repeated attacks on their intellectual property rights. We already know that Chinese companies steal U.S. technology and sell it back to us. I hesitate to think what will happen when actors backed by unlimited resources of the Chinese government will go after these small businesses at the PTAB. I want to make clear that to maintain our nation's innovative superiority, we don't need to rely on prejudices and hate. Our country has seen an alarming rise in physical assaults, civil rights violations, and other general harassment of Asian Americans for no reason other than being Asian. I want to be clear that we are talking about a concerted effort by the Chinese government, not the Chinese Americans and not others with Asian heritage, to steal U.S. intellectual property. We are in an innovation war with China, but we don't win that war by giving up our values and giving in to hate. In my view, we win by strengthening our intellectual property laws and policies, and by placing our American inventors, regardless of race, ethnicity, or national origin, in the best position to out-innovate the Chinese government. And so I call on each and every one of us in this subcommittee from both sides of the aisle to work together towards solutions. We must get to work right away. There's no time to waste. And with that, Mr. Chairman, I yield back.
I thank the gentleman, and it is now my great pleasure to recognize the ranking member of the full committee, my longtime partner on this subcommittee, for his opening statement, Mr. Nadler of New York.
Well, thank you very much, Mr. Chairman. Mr. Chairman, excuse me. A little over 20 years ago, the free world undertook an experiment and allowed the People's Republic of China to become part of the World Trade Organization, granting that nation permanent access to some of the most important markets in the world. Among other changes, this concession meant that China and Chinese companies had permanent access to our patent and trademark systems on the same terms as our own nationals. I voted against China's entry into the WTO because I had serious concerns about the impact that globalization would have on American workers, a concern that unfortunately has largely been borne out. I was also skeptical that many of the promised benefits of free and open trade with China, such as democratic liberalization and improved human rights for its people, would come to pass. Sadly, this concern, too, has largely been vindicated. Today, we see a government in China that has become increasingly authoritarian, using a vast array of technology to track its citizens and subjecting many of its people, most notably the Uyghur population, to shocking human rights abuses. On the economic front, China's entry into the free market system has failed to encourage the PRC to obey the rules and customs that govern the international economic order. Rather, it has simply enabled the Chinese government to manipulate those rules to its advantage. For example, a requirement that in certain high-tech sectors U.S. companies work with a Chinese counterpart has become one of many vehicles that the PRC has used to force technology transfer to their nation. This sometimes means requiring U.S. companies to disclose key aspects of their technology in order to obtain licenses to operate within the PRC, among others. Unfortunately, there are also many documented instances of the PRC using outright illegal means to access U.S. technology, including cyber espionage and trade secret theft. In sum, while the PRC was welcomed into the free market system, it has failed to honor many of the hallmarks of good global citizenship. This is a serious challenge to a system that has historically relied in large part on assumptions that the players will act in good faith. But with the announcement of a series of national policies aimed at making China a technological leader in all important emerging areas of innovation, we cannot afford to be blind to the illicit and questionable means that the PRC is using to leapfrog the rest of the world. Their actions create an uneven playing field for other nations, their people and their companies, compounded by research showing that China's patent system and courts do not always treat foreigners equally. This is certainly a broad topic worthy of our subcommittee's extended attention. While we are primarily focusing on trade secrets and patents today, I would be remiss if I failed to mention that on the copyright front, piracy in China also continues to do damage to the U.S. economy and to hurt the American creative community. I hope that we will be able to explore this and other topics, such as competition in the artificial intelligence space and cryptocurrency, in the future. I want to express, however, that our need to have a serious conversation about the behavior of the Chinese government should in no way be interpreted to call into question the patriotism and the substantial contributions of our many citizens of Asian descent. We have seen all too often how the lack of nuance in our rhetoric can turn into suspicion and violence against some of our own people. Not only is this morally wrong, but it also tears apart our national fabric, which plays right into the hands of our adversaries. It's with the united front and the full empowerment of our tremendous human capital that we in the United States have been the world leader in innovation for so long. We must embrace and expand on that great advantage of ours, in addition to doing the careful legal work of this subcommittee to ensure that our intellectual property laws and policies meet this moment of global competition. I thank the witnesses for their participation in today's important hearing, and I look forward to their testimony. With that, Mr. Chairman, I yield back.
I thank the gentleman, and I have now pleasure to introduce today's witnesses. Mr. William Evanita is the founder and CEO of Evanita Group. He has served in the federal government for 31 years, including the director of the U.S. National Counterintelligence and Security Center, chief of the Central Intelligence Agency's Counterespionage Group, an assistant special agent in charge of the FBI's Washington field office, where he led operations in both counterintelligence and counterterrorism divisions. Mr. Jameson Geer is a partner at an international trade team of King and Spalding, where his practice covers trade remedies, trade policies, and negotiations, trade agreement enforcement, export and import compliance, exactly what we're talking about now, CFIUS matters. He previously served as chief of staff to the U.S. Trade Representative under the previous administration. Mr. Mark Cohen is a distinguished senior fellow and director of the Asian IP projects at Berkeley Center for Law and Technology. He previously served as senior counsel to the U.S. Patent and Trademark Office and as first representative of the USPTO in China. Mr. Charles Dwan is a policy fellow and adjunct professor in the program on information, justice, and intellectual property at American University College of Law. He serves as a member of the Patent Public Advisory Committee of the USPTO. We want to welcome our witnesses and thank them for appearing today. We will begin by swearing, as is the rule of the committee, swearing in. Would you please rise and raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you are about to give will be true and correct to the best of your knowledge, information, and belief? So please say aye if you do. Please be seated. Let the record show that all witnesses answered in the affirmative. And then I'm supposed to say thank you, be seated, but I'm rusty at this. Please know that although your testimony is limited to 5 minutes, all of your written statements, opening statements, any additional information you want to submit within 5 days after this hearing will be placed in the record. So feel free to abbreviate. You're all pretty good at looking at clocks. Please try to stay right on that 5 minutes or as close as possible. And with that, we start with Mr. Evanita.
Chairman, Ranking Chairman, members of the subcommittee, it's humbly a pleasure to be here with you today. As the Chairman referenced, I spent over 31 years in the United States government with the FBI, CIA, and as the first Senate-confirmed director of the National Counterintelligence and Security Center. However, I'm here today as the CEO of my own company, where I spend most of my time dealing with CEOs, boards of directors, and executives, fighting the economic war we're currently in with the Communist Party of China. And that certainly starts at the very beginning with the protection of their intellectual property, trade secrets, and business rules. Economic security is national security. There could be no doubt to that. Our economic prosperity and security of such drives our prosperous economy, which provides for the best national security, military security, and military apparatus the world has ever seen. However, let us be clear and honest. Our economic global supremacy, stability, and long-term vitality is not only at risk, but clearly in the crosshairs of Xi Jinping and his communist China regime. So how does China steal intellectual property? The Communist Party of China uses intelligence services, science and technology investments, academic collaboration, research partnerships, joint ventures, front companies, mergers and acquisitions, and outright theft via insider threats and cyber intrusions. This whole-of-society approach, utilized by the Communist Party of China, sets the comprehensive and strategic framework for how China implements their grand strategy. It is currently estimated, as the chairman referenced, the economic loss from the theft of intellectual property and trade secrets just from the Communist Party of China and just from what we know via prosecutions is between $400 billion and $600 billion per year. To make it more relevant and personal, that equates to about $4,000 to $6,000 per American family of four after taxes. The economic cost to intellectual property theft is real. China's ability to holistically obtain intellectual property and trade secrets via legal, illegal, and sophisticated hybrid methods is like nothing we have ever witnessed. Actually, it is said by many to be the largest theft of intellectual property in the history of the world, and it just happened in the past decade. So what intellectual property does China steal? Well, everything. China's priorities for obtaining US-based intellectual property, trade secrets, ideation, and technology is pursuant to the publicly available Made in China 2025 plan. It is clear, concise, and at the same time strategic and comprehensive. Just to name a few: aerospace, deep sea technology, biotechnology, information technology, manufacturing, clean energy, electric battery technology, and DNA genomics are just a few. Any CEO, board of director, in any of these critical industries must be acutely aware of the threat posed to them. They must work efficiently and aggressively with their security teams, legal counsels, and outsiders to identify risk-based mitigations to this threat. And this needs to occur yesterday. The proverbial salt in the wound of intellectual property theft is when the Communist Party of China steals our thoughts, ideas, patents, and technology, and it manufactures that same technology inside China, and then turns around and sells it back to American companies, states, and localities. One needs to look no further than the American Supercomputer Corporation just for a glimpse of the long-term pain and impact of intellectual property theft and espionage. Additionally, one must factor in all the manufacturing plants which are not built in the United States and the tens of thousands of jobs which are not created because China, via its theft, beat the United States to the global market and sells that same US-created product, idea, and patent at a significant reduction in real costs. Just this past November, Yanjun Zhu was sentenced to 20 years in federal prison for targeting American aviation companies, recruited employees, traveled to China, and solicited their proprietary information, intellectual property, on behalf of the government of the PRC. He's a highly trained intelligence officer, Deputy Director of China's Ministry of State Security. Coincidentally, next month, China will roll out the first flight of the COMAC airliner. It is 95% stolen of intellectual property from the United States and around the world. It is clear intention this effort is both to compete and eventually overtake Boeing and Airbus. So why does this all matter? Because continuing to combat this threat begins at subcommittees and hearings like this, where the American public and members get to understand the significance of the threat we face every day by the Communist Party in China. The why matters. I thank the subcommittee for your attention and look forward to your questions.
Thank you. Mr. Geer.
Good morning, Chairman, Ranking Member, members, and staff. I should note before beginning that I'm appearing in my personal capacity and none of my comments today can be attributed to any current or former employer or client, although I hope that many of them agree with me. I'm heartened to hear the consensus between the chairman and the ranking member on these important issues, and Mr. Nadler, I'm right there with you on China's entry into the World Trade Organization. I'm grateful for the opportunity to appear before this subcommittee to address one of the most important issues for our U.S. economic and national security, that is our strategic competition with the People's Republic of China and the role of IP in that competition. As a former officer in the U.S. Armed Forces, former Chief of Staff in the Office of the U.S. Trade Representative, and a practicing international trade attorney in the private sector, I view these issues through both an economic and a national security lens. I've heard directly and hear directly from U.S. businesses and workers on how the Chinese approach to IP has injured their economic prospects, those of the U.S. businesses. I've worked to develop and implement U.S. policies to counter these harmful practices, and I've been part of U.S. teams tasked with negotiating with Chinese officials on these critical issues. These experiences all underscore for me the seriousness of this challenge and the continuing and urgent need to take strong action It's difficult to overstate the importance of IP for the U.S. economy and workers. The U.S. Patent and Trademark Office found that IP-intensive industries account for 41% of domestic output and 44% of U.S. jobs. That was a 2019 study. U.S. military superiority and accelerating Chinese military capability are driven by IP-intensive technology. U.S. innovation must be defended, including through negotiation of concessions by China to protect IP rights, and where necessary, and this is increasingly important, very strong enforcement of trade agreements and rules to obtain compliance. The optimal policy prescriptions for dealing with China's approach to IP are tied to how one views the overall challenge posed by China. I'm concerned, as you all are, that China has used its access to Western technology to try to become a hegemon and to eliminate key Western industries and our economic strength. Those who don't share this assessment will have a different view of the appropriate policy response, but we need to make sure we have all the facts before us, so this hearing is very helpful. I won't go into detail on the ways that China steals technology. Mr. Evanina has done that, and I think we will discuss it in more detail. And we've also heard about the harm. Chairman Issa talked about upwards of $600 billion in cost to the U.S. industry every year. It's important to me that we all understand the historical context of this issue, which unfortunately is not new. The administrations of George H.W. Bush and Bill Clinton each made efforts to negotiate improved IP rights and enforcement in China in 1989, 1992, 1995, 1996. Each of these efforts resulted in small agreements with commitments by China to change. They didn't change, and unfortunately there was no enforcement following that. As Mr. Nadler pointed out, despite all of that, China was the red carpet was rolled out for China to enter the World Trade Organization and became also as part of that, the agreement on trade-related aspects of intellectual property, CHIPS. And then we saw under the Bush administrations and Obama administrations a series of dialogues where China once again agreed to make changes. In fact, you can see that if you look from 2010 to 2016, there are 10 occasions, some including Xi Jinping himself, where China agreed that they were going to make changes on IP. Again, promises are great, discourse can be helpful, but there was no enforcement. Fast forward then to 2017, when President Trump directed my former boss, Bob Lighthizer, to investigate China's practices under Section 301 of the Tariff Act of 1930, and most importantly, to take action if warranted. In the Section 301 investigation, which I have the report right here in my hand, I hope some of you have it too, it found that China was harming the U.S. economy through its practices. We can talk about all these different things, like I said, but some of the most beneficial outcomes of the Section 301 investigation have been, first, imposing tariffs on high-tech items from China to prevent our dependence on China for such items that are often produced from stolen IP. Think here electric vehicles, robotics, aerospace items like Mr. Evanina was discussing. And the second thing is we did obtain commitments from China to improve its IP system, particularly for trade secrets, and to eliminate forced technology transfer. Now, we're not naive in thinking that China can sign a piece of paper and we would get them to change, but that's why the tariffs were kept in place to maintain leverage. And the Biden administration in the past has stated that they embraced the Phase 1 deal that came out of this investigation, including the tariffs. And although the Chinese have made some changes consistent with their Phase 1 agreement obligations, stakeholders agree that these efforts, although welcome, are insufficient. So where do we go from here? And I'm happy to talk throughout the hearing today about how we can use existing tools to combat IP theft by China and how we might develop new tools as well. There are a number of tools at hand, but the underlying use of any of these tools, you have to have the political will across parties and administrations, and importantly in the U.S. business community. Absent the sustained will, it will be increasingly difficult to protect the U.S. economy and American workers from the negative impact of Chinese policies and practices on IP. Thank you.
Thank you, Mr. Greer. We now go to Mr. Cohen for 5 minutes.
Thank you very much, Mr. Chairman and Ranking Member and members of the committee. It's my honor to testify before you today. I'd like to use my 5 minutes to begin by answering a question that I am asked every day, and I suspect many of you are too. The question is, does China protect IP? The response is yes and no. The answer lies in what we know, what we do not know, and what is hidden from us. Imagine 3 stacks of paper before me on this table. Stack 1 is favorable to China. It contains empirical analysis of China's IP system. It contains reports of American companies, business surveys, and scholars who often praise the efficiency, low cost, and fairness of China's IP system. Although the opinions in this stack are contrary to the prevailing positions within the Beltway, there's actually a great deal of information in that stack. Stack 2, equally large, commands your attention with its stories of IP stolen by China. I won't repeat them because we've already heard quite a bit, and I'm sure we'll be hearing more about these stories. Typically, the case stories are anonymized because victims also fear retaliation. These two stacks describe one legal system. It functions very well until it doesn't. Chinese politics intervenes in an important but a minority of high-value disputes in China's legal system. Many of these cases concern technology, and yes, many of them concern Americans. There's also a third stack on the table. It contains invisible records of the many cases and controversies which have never been published and about which we know very little. This stack includes cases where the CCP secretly intervened to compel a decision adverse to a party. It includes cases where there was national technology policy involved against an American company, perhaps antitrust, patents, or trade secrets. It also includes cases involving lost business opportunities. There are numerous other invisible disputes. To fully understand this third stack, however, we would require greater transparency from China, and we have not gotten that. Sadly, the Phase 1 agreement did nothing to resolve this problem. For example, it imposed no obligations on China to publish its trade secret cases, to make court dockets more available to the public, or to improve transparency of the administrative patent linkage decisions. These deficiencies haunt us today, as they have for the past 2 decades. These 3 stacks tell us 3 complementary messages. Foreigners win IP cases in China. Foreigners are often victims of China's IP policies. And the third, we still do not fully comprehend how foreigners are being treated in China. Although these conclusions are compelled by China's lack of transparency, I believe that there are nonetheless tools that we can use to help us be better informed and make better strategic decisions. It's time for Americans, for the United States, to leverage the full range of data that we have on patents, on scientific publications, on manufacturing investments, industrial policy, customs intelligence, et cetera, to better assess our competitiveness and China's strategic goals. We might reconsider instituting the Office of Technology Assessment, which conducted many trailblazing technology assessment practices here in this body for US government and industry. We need to develop future-oriented technology assessments in key technological areas of concern. And I've seen these reports from China in great detail where they've enumerated how they would deal with US technological threats. We need to do the same. For law enforcement, that means we should be expending our efforts based on risk assessments that target key technologies, not on targeting ethnic groups. We should also consider reinstituting DS-362, the WTO case from almost 15 years ago that sought to compel greater transparency for the Chinese IP system. The good news in all of this is that China is in many respects a planned economy, and many plans are published, so it is really not too difficult to determine where China is targeting its efforts. I'd like to close for a moment by referring back to a statement by the chairman about the Federal Trade Commission proposed rule to ban non-compete agreements. And I could agree completely with your assessment. In fact, I believe that California would be well advised to suspend its ban on non-compete agreements when there is an international context. Right now, we've seen tremendous losses in California and from the United States generally when there's poaching of US employees or there's disclosures of confidential information in violation of NDAs or confidentiality agreements. China's own statistics prove that non-compete agreements are much easier to enforce than bringing a trade secret case. The chance of winning a trade secret case in China today is about 30%, whereas the chance of winning a case based on a non-compete agreement is anywhere from 66% to 90%. So we're actually impairing the ability of our own companies to enforce their rights in China. Privately ordered non-compete agreements are critical to prevent loss of trade secrets. I'm happy to provide more data to the subcommittee on this topic. Once again, thank you for inviting me to speak with you today.
Thank you, Mr. Cohen. We now go to Mr. Duan for 5 minutes. The gentleman is recognized.
Good morning, Chairman Issa, Ranking Member Johnson, and members of the subcommittee. Thank you for inviting me to testify today on this important topic. Similar to Mr. Greer, the views I'll express in this testimony are my own, not those of any affiliated organizations or institutions. Intellectual property is the infrastructure that underpins and shapes American innovation. And as with any other infrastructure, its reliability and trustworthiness are critical to national security at a time when technological progress defines American leadership around the globe. My colleagues have discussed the defensive role of intellectual property protecting against China's IP theft. I'd like to focus on a different aspect that, Mr. Chairman, you've alluded to quite a bit in your discussion, an offensive role in which China and other competitor nations might exploit our IP system by obtaining and asserting US patents in ways that unfairly harm American innovators. My written testimony reviews a number of ways that China could and does offensively exploit American patents, but here I'd like to focus on one example that I found. 2 years ago, the holder of a patent on an autonomous vacuum cleaner demanded that Amazon remove a product listing of an allegedly infringing competitor. Under its patent-neutral evaluation rules, Amazon notified the seller. The seller almost immediately brought suit against the patent holder, charging that the patent had been wrongly granted and that it should be invalidated. So far, this sounds like a typical story of a patent dispute, and indeed, it involves an American startup and a massive Chinese conglomerate. In this case, though, the patent holder was the billion-dollar company Xiaomi Electronics and its subsidiary Beijing Rockrobo. The alleged infringer was a company based out in Washington State. In other words, you had a major Chinese firm asserting a US patent against a US business. Now, I want to be clear, there's nothing wrong with a Chinese company obtaining, holding, or even asserting a US patent. It would violate our international obligations to say otherwise, and discriminating against patent holders based on nationality would only encourage other nations to do the same, or even worse, to engage in a tit-for-tat sort of competition. Additionally, I'd like to thank Mr. Ranking Member for mentioning the concerns about discriminating based on ethnic origins. I think that that's an important point that I want to carry through this hearing. My point here, though, is simply this. Patents defend Americans from foreign IP theft, but that's not all they do. As Mr. Chairman and Mr. Ranking Member, you mentioned, trade secrets can often be the better tool for the sort of defensive job protecting us from IP theft because of the territorial limits of patents. The more concerning role in my mind of US patents is this sort of offensive use. Companies like Huawei, as you mentioned, Mr. Chairman, asserting them in the United States against small businesses and American innovators. Already, we know that over 50% of US patents go to foreign applicants. China is poised soon to be the top filer of US patent applicants, likely to overtake Japan in just a couple of years, and particularly is focusing on sensitive fields like 5G and artificial intelligence. If US patents can be obtained too easily, or can be asserted unfairly, then China could strategically use them to hamper American innovators and slow down our technological progress. How do we respond to this potential offensive use of patents? Well, just as trusted computing systems protect us from cybersecurity threats, we need a trustworthy patent system, one that protects American entrepreneurs from abusive patent assertion from China and elsewhere. We need to dedicate resources to patent examiners to ensure that patents are correctly reviewed. We need processes to validate the correctness of patents after the fact, knowing that patent examination is not perfect. We need to champion fairness in the adjudication process. Courts in China and elsewhere, even in the United States, Mr. Chairman, you mentioned the International Trade Commission. There's a race to the bottom of unfairly tilting the playing field in order to attract lucrative patent cases. We need to be a global leader on forum fairness to put a stop to Chinese anti-suit injunctions and other judicial manipulation. And finally, we need to engage the whole of government on technological leadership. IP rights are an important component, but not the only component of that, especially for dynamic fields like artificial intelligence. Policy tools such as STEM education, high-skilled immigration, research funding, and diversity initiatives can have tremendous impact beyond what patent law alone can achieve. I thank the subcommittee for its attention to this issue and look forward to your questions.
Thank you. I'll forego my questioning for now and go to Mr. Fitzgerald.
Thank you, Mr. Chair. Mr. Evanina, shortly after the Olympics, Summer Olympics in 2008, I was able to travel to Beijing for 10 days. And I remember how shocking it was to see how the city had been cleaned up and westernized for all those traveling for the Olympics. It also was a period of time in which I think many American corporations were not only being lured to do business in China, but certainly were more than willing to do that. And I wanted to preface kind of a question for you along those lines. So because the Chinese government has historically required foreign companies seeking to do business in China to establish the joint ventures with Chinese-based companies, particularly in industries such as oil and gas, exploration, medicine, insurance, and radio and TV items. And now the National Bureau of Economic Research found in 2015 alone, foreign companies set up slightly more than 6,000 new joint ventures in China. It accounted for almost $28 billion in foreign direct investment. And then the same study also found that as soon as 3 years after inception of these joint ventures, we all kind of know what's going on, the Chinese firms in that same industry not only exceed the technology that was brought to them by American corporations, but then also increase the productivity related to that entire industry. So my question to you is, sometimes I think we're our own worst enemies in this area, in that we continue to allow corporations to enter into these joint ventures. They, at the end of the day, come away with millions of dollars in new revenue and productivity, but are we kind of chasing our own tail in this regard? I'm wondering if you could respond to that.
Congressman, thanks for the question. A bit complicated response, but yet simple in terms of thought process. I think a couple things are true with your statement. Number one, we don't play by the same rules as the Communist Party of China. We have the greatest capitalist society country in the world has ever seen, which results in businesses and industries wanting to invest globally to have a significant return on investment. And that has been true for 2 decades with anything you invest in with the Communist Party of China or companies that are within that country. So that is true. So it's hard to say to a capitalist society business entity, don't invest in China because of X, because we are a capitalist society. But for the first time ever, I'll proffer to the subcommittee that we are in a space right now where our global supremacy, our capitalist mindset is clearly superseding and overlapping with our national security and national interests. And I think it's going to be a crosshairs where we have to now look at what's the obligation of a financial industry, of a corporate or startup to say, listen, your investment in the Communist Party of China is fair from a capitalist perspective, but it's written with security issues for you and the nation. And let's look at your issues in your next quarter earnings versus the national interest and national security. I think that's a really tough conversation to have, but we're going to have that.
And I'll just follow up with, just as of this week, I've had colleagues in Congress say we need to set a path for many American corporations to wean themselves off of this. And I think that the only clear path to doing that is probably legislation at some point. So I'm wondering, any thoughts on should we go that far? And if we do go that far, what the fallout might be?
Yeah, that's a great legislative question, a policy question about that intersection between Congress and the private sector with respect to capitalism. But I will say that I believe with the impending Taiwan situation and what happened in Hong Kong and the course we're on with the Communist Party of China, that eventually investors in China will start to feel the pain. And I think they will start to begin to not be able to withdraw the money from investments. And I think the Communist Party of China will start to force us to feel the pain of that investment. I think that will change the course of American investment in China.
Thank you very much. I yield back.
I thank the gentleman. We now recognize the ranking member of the subcommittee for his for his questions.
Thank you, Mr. Chairman. Mr. Cohen, you testified that U.S. policies and laws weakening our patent system in key areas, such as patent-eligible subject matter and the availability of injunctive relief, have given China an opportunity to surpass us in innovation. Can you explain in more detail how China has exploited our weakened patent system?
Yes, thank you for your question. To someone who observes IP developments on both sides of the Pacific, it was interesting to me to see that at the same time as cases like Myriad and Bilski were decided by the U.S. Supreme Court, China amended its examination guidelines to permit the very same subject matter, ineligible patents to be granted in China. Now, this was probably due in some small measure to the U.S. Supreme Court decisions and an opportunity perceived by the Chinese Patent Office, as well as China's own economic growth, that it was becoming very successful in fintech, in genomic discoveries, and medical diagnostics and related areas. So there's a bit of self-interest here, as well as a bit of a competitive edge. Studies that have been done by Adam Mossoff at George Mason, Dave Kapos and others have shown that in many cases, patents that were ineligible in the US were eligible in China and the European Union and many other countries. That's one aspect. The other aspect is eBay. Now, in China, injunctions are basically automatically granted if there's a finding of infringement. This is really critical to China because damages are low. So having an enforceable injunction means that you actually have a useful remedy in China's huge market where so many goods are manufactured and sold. So that becomes an attractive position for China to play in attracting global litigation. And I should say that part of this is is by no means secret that China wants to be a center for global innovation. So it wants to attract these cutting-edge industries, and we've seen it with companies like Alibaba and Baidu and Tencent and others. But it also wants to be a center for international IP litigation. And how that evolves is a bit unclear. But they do have a cadre of over 2,000 IP judges, 2,000. And not only that, but many of these judges and IP officials have since been promoted to higher levels within the Chinese government. I think we have yet to appoint a federal circuit judge to the U.S. Supreme Court. China has had at least 2 IP judges appointed as justices of their Supreme Court. And we've seen other promotions within the Chinese bureaucracy. Xi Jinping...
Well, let me stop you right there.
Yeah, sure.
And let me ask you this question. In your view, how would making injunctions easier to obtain make U.S. corporations more competitive with China?
Well, it makes China a more attractive place to litigate. Obviously, injunctions that are abusively asserted will not advance U.S. innovation. But the availability of injunctive relief for those who practice inventions is a significant advantage. And there's no doubt in China that that injunction is available if there is a finding of infringement.
Thank you. I'd like to ask anyone who cares to respond. I'm particularly interested in the ability of small businesses in advanced areas of technology to be able to grow and thrive. I believe this is one of our greatest sources of competitive strength against China. What challenges do you think that our small businesses face when they try to enter the Chinese market with respect to intellectual property rights that big businesses might not? And are there remedies that Congress should consider in response?
I can tell you that statistically, if I may answer, small businesses have a very low utilization rate of the Chinese IP system. That is small foreign businesses. So you're looking at less than 1% of the patent applications, for example, and probably a very small cohort of the litigation as well.
Why is that?
Some of it is lack of knowledge. Some of it is that small businesses may be focused on the U.S. market, and they may be unaware that their products are being infringed, counterfeited, their information may have been stolen in the Chinese market, so there's that as well. Barriers to entry, such as high legal costs, where they don't know how to secure the proper advice. The USPTO is a great outreach program, the China Roadshow, where we do reach out to small businesses. It was a core part of my function when I was attaché. And I know those have been expanded over the years as one tool that we have, but I think it is a continuing problem frankly, that small businesses have difficulties enforcing their IP rights in China and frequently don't even take the basic steps of securing the right to begin with.
Thank you.
Ranking Member, I'd like just to add on to the great points just heard, amplify a little bit of a defensive perspective. I see small businesses and startups with a significant inability to protect what they're doing at any cost. So because they are mission-oriented and trying to drive a wedge into the new industry they're trying to develop, they don't spend a lot of money on robust security, CISOs, CSOs, general counsels, people who advise and inform on the patent process. So what makes them most vulnerable, their inability to protect that from ideation through manufacturing provides an unbelievable vulnerability to attack from the Communist Party of China, which prevents them from getting that foothold in the marketplace.
Thank you, and I yield back, and I thank the chair for his indulgence.
And I thank the ranking member for his thoughtful questions. We now go to the gentleman from Virginia, Mr. Klein.
Thank you, Mr. Chairman. I want to thank you for holding this hearing. I'm glad to see it's part one, and there are going to be many more to follow. But you know, when it comes to intellectual property, the Chinese Communist Party has been eating our lunch for many years across both parties' administrations. I wrote down they're eating our lunch. Now I think it needs to be changed to they've been stealing our lunch money and parading it in front of us. But we're in the Biden administration, so let's talk about the Biden administration. Their own policies are further gifting the CCP with more ways to steal IP from American innovators and companies. 3 ways in particular: ending the DOJ's China initiative, supporting the WTO's TRIPS waiver, and the FTC's recent proposed rule regarding non-compete agreements. First, I want to go to Mr. Evanina, and let's talk about the China initiative. Last year, the Biden administration shut down this initiative, begun during the Trump administration, a national security program focused on prosecuting IP theft by Chinese government agents. In the weeks leading up to this decision, Director Wray called China the biggest threat to U.S. security. Would you agree with that assessment? And can you talk about the national security implications for the U.S. If China continues to achieve its goals to move into the aerospace, pharmaceutical, and information technology spheres?
Congressman, thanks for that question. And I would proffer by saying there is no extent to hyperbole when it comes to the Communist Party of China. And eating our lunch is probably minimizing the risk in the theft. And I concur with Director Wray and anyone else who talks about the reality and the facts behind what we see here. To address your China initiative issue, my information is that that was a decision to change the name of the initiative, right? So from what I understand, the cases continue. There's still over 1,000 Chinese cases of economic espionage, theft of trade secrets, and intellectual property that continue today. That was probably a political decision to satisfy constituents and get rid of the word name Chinese. But the issue continues to bear fruit. I do think that this is a whole society approach to defending what we're seeing every day, and it's going to take Congress and the entire country to help mitigate the threat.
Thank you. Mr. Cohen, let's talk about Chair Lina Khan's announced rule that would prohibit non-compete agreements nationally, coming on the heels of California weakening or eliminating the enforceability of non-compete agreements, which China has, as we know, capitalized on. In your article, The FTC's War Against U.S. Technology Competition with China, you wrote about the relationship between non-competes and trade secret protection. And can you talk about that, and can you talk about instances where California's refusal to enforce non-competes has affected trade secret protection?
Yes, thank you very much for your question. To get to the second part of your question first, I draw your attention to a case involving Gerald Yin who was formerly at Applied Materials. He went to establish his own company in Shanghai with about 30 other Applied Materials employees to engage in semiconductor manufacturing equipment. Mr. Yin has, I believe, according to a Wall Street Journal article, was placed on the entity list by the Department of Commerce last October. This is a critical technology. It's directly competitive with our own companies, and it would enable China to produce leading-edge semiconductor equipment. See, I have no problems domestically with non-compete agreements, if that's what the country wants to do. I have a problem with facilitating poaching of U.S. employees by foreign companies overseas. And I think this could actually create a great risk for the CHIPS Act. We're going to see several large fabs built in states which enforce non-compete agreements, not in California, regrettably. But if you can imagine TSMC sending a whole team of its best employees to Arizona to build a state-of-the-art fab, a Chinese company comes along and says, I'd like to bring out a team of 30 of your best employees to China. And there's nothing to stop that if non-compete agreements are invalidated. So there's an important deterrent effect. The other thing is that trade secret litigation is usually after the fact, after the stuff is stolen. It's rarely granted as a matter of a preliminary injunction. So you're basically in a position where whatever remedy you got may be inadequate to address the loss. And that's part of the reason non-compete agreements are the most effective, your first question. Because by being able to prosecute a non-compete agreement, you don't have to prove that there's a trade secret. You just have to prove that there is a violation of the obligation to not work for a competitor. This also mitigates the risk of secondary loss, which happens in a trade secret case when you reveal your confidential information to a court or to an administrative agency. You don't want to have that happen, and that's one of the reasons that some companies don't want to bring trade secret cases, because they're afraid there will be a secondary loss. So a non-compete agreement is easier to enforce, it's cheaper, it mitigates the possibility of secondary loss, and as I mentioned earlier, the chances of success, if you were to bring the case, for example, in China, and I believe in most other countries in the world which permit non-compete agreements, are much higher than if you were to litigate a trade secret case, and less expensive.
Thank the gentleman. We now go to the ranking member of the full committee, Mr. Nadler, for 5 minutes.
Thank you, Mr. Chairman. Mr. Cohen, there are a lot of reasons why some of us favor non-compete agreements. What would you, but I understand the concern about China. What would you think about if we were to pass a national non-compete agreements, but say that it doesn't apply to Chinese companies?
Yeah, I think and my conflicts of law teacher would say you would have a renvoi provision, that is, that you would let it be governed by foreign law. I mean, China has its own restrictions on non-compete agreements, and I think if you left it up to companies to draft non-compete agreements that comply with foreign law, that would be a solution to addressing the problem of poaching of trade secrets by foreign companies of U.S. technology. So that could apply to any country in the world. It doesn't necessarily need to only apply to China.
So you think it's a good idea?
I think that's a good idea. I think actually that would be a good provision for California to add on to its existing ban on non-compete agreements, that a non-compete agreement would be enforceable in an international context. And frankly, before the FTC came up with that proposal, I was trying to develop some momentum to amend the California law.
Thank you. Mr. Duan's written testimony makes a point of noting the low quality of Chinese-owned patents, while Mr. Cohen's testimony cites research suggesting that China is currently the world leader compared to the United States in 37 out of 44 advanced areas of technology. I find it difficult to reconcile these two statements, and in particular, I'm concerned that we are unwittingly blinding ourselves to appreciating how serious our competition with China already is. Mr. Cohen and Mr. Duan, would you like to comment on this? First, Mr. Cohen.
Well, I think we have blinded ourselves for over 20 years in not dealing with the technological threats that China presents. And if we had time, I could go through my own horror stories as a U.S. government official, where I have tried to get American agencies to recognize that trade secret protection is enormously important, technology licensing is enormously important, patent protection, plant variety protection, all the technological areas of intellectual property need to be front and center. China always had a goal of regaining its historic Industrial Revolution era supremacy in technology. This is nothing new. What is sad is that we did not recognize China's emerging competitive edge in so many areas, through legitimate practices and less legitimate practices of the type we've just heard from. And I think this really calls for a rethink in the U.S. government, not only of what went wrong, but more importantly, how we can come up with better strategic decisions that are based on facts, that anticipate existing and likely future challenges.
Thank you, Mr. Duan.
Yeah, I think the first part of answering that question is distinguishing between patents and innovation, right? It's possible to file a patent application on a very simple technology, one that doesn't really push the boundaries. And what we've seen from a lot of Chinese patent applications and patents is that because of the subsidies that China has provided, because of the quotas that China has used, China has encouraged the filing of a lot of patent applications, but often ones that are of these sorts of low quality. The petty patents that China offers that require less examination, provide less protection, and don't really demonstrate the sort of innovative capacity that a full-fledged US patent would provide. Now, that's not to say that those patents are useless. In fact, we have examples from American law history in which a flood of low-quality patents ended up getting into the hands of entities that were often shady and we couldn't figure out what was going on with them, becoming tools in which companies could assert them against small startups, against small businesses, preventing Main Street restaurants from putting menus, from putting electronic menu displays up, things like that. So that's where I would be concerned that even though there are lots of low-quality patents, they might turn into these problematic tools.
Thank you, Mr. Cohen. A basic premise of the treaties governing IP to which the U.S. and China belong, the TRIPS agreement, is that foreign entities will have the same access to patenting and court enforcement of those patents as nationals. According to your testimony, however, it seems that U.S. companies, as well as other non-Chinese companies, are not availing themselves of the Chinese court system to enforce their patents much at all. In other words, it seems that we are de facto not getting the benefit of the bargain anticipated in the agreement. Do you agree with this? And if so, how would you recommend we consider responding?
Well, I agree with the statement, and I think this points to a problem that is little talked about, which is low utilization of the Chinese IP system by foreigners. Now, this may be because some foreigners are frustrated. They have a lack of confidence in the system. But when you try to take the low utilization rate and also compare it to the high success rate, it's a dilemma that's very hard to resolve. In some areas, like software piracy, Microsoft, for example, according to published data, has had a 100% success rate in litigating software piracy cases, as have most of the other large software companies. In patent litigation, numerous studies show that foreigners win at a higher rate than Chinese litigants in patent infringement cases, that they are more likely to get higher damages, and that they're more likely also to get injunctive relief. In one case, actually, the Beijing High Court, for 1 year, the success rate at that important court for foreigners litigating IP cases of all types was 100%. So how do we explain low utilization? I think part of it is also attributable to the fact that many foreign companies view IP litigation as not so much a legal act, but a political act. There's a cost. They're going to have to lobby the Chinese government. They may have to lobby the US government. There may be a public relations cost. And when they put all those things together, they end up backing away from the Chinese IP system. But I have to point out one other thing, which is that litigation, whether successful or a failure in China, is a critical source of information for the kinds of discussions we're having today. If you cannot sue the Chinese government or a state-owned enterprise, for example, for IP infringement, that is important information for us to know as we think about the proper policy going forward.
Thank you. My time is well expired, and I yield back.
I thank the ranking member. With that, we go to the gentleman from Texas, Mr. Gruden.
Thank you, Mr. Chairman, and thank you, Mr. Evanina. I want to mention what we had just talked about with my colleague from Virginia about the China Initiative, and remind people that in 2018, the Department of Justice established the China Initiative, aimed at securing our critical infrastructure against foreign threats, specifically the CCP, and prosecuting bad actors engaged in theft of intellectual property. Despite its overwhelming success, the Biden administration suspended this program. And I wanted to point out that yesterday I introduced a bill to reestablish this program and counter the CCP's economic warfare and corporate espionage. Would you consider the CCP initiative started under President Trump a success?
Unequivocally, and I think regardless of what you call it, the ideation that the United States government will begin the process of looking at the Communist Party of China and their effective and nefarious practices towards IP theft and economic espionage, no matter what you call that, I think it's the obligation of the United States government and Congress to defeat it.
I would agree with you, and thank you. And I want to also move on and ask what recommendations does the U.S. National Counterintelligence and Security Center have for strengthening trade policy tools to address IP theft by China?
Well, at the time, sir, and I left in 2021, I think robust education is the beginning of it all. And I would proffer that members of this subcommittee and members of other committees and go back to their home districts and have dialogues with their governors and their economic development corporations and their chambers of commerce to show the tools and techniques of the Communist Party's investment in their localities and what that economic espionage and intellectual property theft looks like early before it happens. Because once the FBI comes to town and investigates, the data and intelligence and intellectual property is already gone. And I think that's where we have to get left of boom and start to educate our business leaders and local investment operators on how to protect it and see it first.
Thank you. Mr. Greer, during your time, what trade policy measures were being used to address this issue of intellectual property theft? And do you think these measures have deteriorated? Are we in a better spot or worse off?
Thank you, Congressman. So as I referred to in my initial testimony, we use Section 301 to investigate these practices by the Chinese. There are a lot of different things you can do to address this. Typically, what other administrations have done is they've just had negotiations where they talk. They have a dialogue with the Chinese where they talk and try to get some kind of a concession. What was always absent was enforcement. And so Section 301 was really focused on enforcement. And so in addition to gathering all the information, having a very open comment process where any stakeholder could come in and talk to USTR and share its views, also do it on a confidential basis, which took care of some of the challenges that our businesses face. We were able to understand, quantify the problem, bring it to the Chinese, tell them about it, give them an opportunity to remedy it, and then when they didn't, take an enforcement step. We chose to use tariffs. We chose to put tariffs on IP-intensive items. Is it effective? I want to use the example of electric vehicles. At the time, we were not importing many electrical vehicles from China. It is an item, it is a sector where China wanted to steal technology, where they did, where they forced JVs. We put a 25% tariff on electric vehicles. Today, there is news out there that China has become a major exporter of electrical vehicles, which they weren't at the time, but they are not to the United States. Imports of electric vehicles to the United States, only 3.6% of those imports are from China. It's because of that 25% tariff. There are other things you can do with Section 301. It doesn't have to be a tariff. You can limit services. You can limit other kinds of access to the U.S. market. There are tools there that we can use to enforce, and we need to have the political will to do it.
Thank you. I yield back, Mr. Chairman.
I thank the gentleman. We now go to the gentlelady from North Carolina, Ms. Ross, for 5 minutes.
Thank you very much, Mr. Chair, and thank you to the witnesses for sharing your expertise with us. My district in North Carolina's Research Triangle is home to many innovators and creatives. Regardless of the size of their enterprises or the nature of their work, these innovators, from independent singer-songwriters to investors in R&D, share a common concern: Chinese infringement on the creative work into which they've poured their time, their money, and their dreams. China has long relied on counterfeit goods to gain leverage over U.S. companies. However, China has recently turned to acquiring IP in order to leapfrog our nation in technological innovation. Unfortunately, uncertainty in our own IP system has not helped us maintain our edge. We have seen patent eligibility shift over the past 15 years, in part due to U.S. Supreme Court decisions. And while it's important to keep bad patents from clogging our IP system and hindering legitimate innovation, one analysis found that nearly 1,700 patent applications that were rejected in the United States were approved by both the EU, China, other countries, not ours. This disparity in patent eligibility threatens to drive innovation out of our country and into systems with broader criteria. It's not only investors in R&D who are threatened by China's growing interest in U.S. IP. As TikTok has recently risen in popularity, independent musicians sometimes find their music picking up listeners and even going viral on that app. However, the royalties on TikTok are hundreds of times lower than what other streaming services offer, leaving musicians undercompensated. I'd like to submit an article by Elias Light in Billboard magazine entitled "TikTok Pays Artists Almost Nothing in Music Royalties, and the Industry is Losing Patience," into the record, Mr.
Without objection, so ordered.
So, my first question is for Mr. Greer. Apart from what we've been hearing today and what we might do with China on the legal end, shouldn't we also hold stores, retailers, and the distributors of counterfeit goods in this country accountable? What about the companies that sell products built from IP theft?
Congresswoman, thank you for that question. Yes, I agree with that. When we talk about enforcement as being something that the Chinese understand and that the Chinese can react to, of course we should be enforcing our own IP laws here in the United States. We've heard about Section 337, which is really about imports coming in. But to the extent you have violations here in our country, and maybe it's a subsidiary of a Chinese headquartered company that's doing it right here, why wouldn't you enforce that? I think that's exactly the right approach.
Thank you. And Mr. Cohen, is it true that China's patent system is more aligned to how our patent system worked decades ago? And is China making their own patent laws stronger as they become more of an innovator nation?
Great question. The Chinese patent system was basically modeled on the German system at its outset. And I think over the past 10 to 20 years has been a profound influence of the United States. There was a tremendous reluctance in the 1980s for China to have a patent system. There was a sense that no individual in a socialist economy should have a private property right in an innovation. And originally the patent system was largely catering to foreign interests. China discovered that patents, when they were acquired by foreigners in China, were the opening door, if you will, to foreign investment. So their motives to have a patent system were actually intended very clearly to attract foreign investment, to attract foreign technology. That was really what they were trying to do at the outset. The system has become stronger and more sophisticated. I mentioned the 2,000 IP judges. The growth of the patent office has been phenomenal. I mean, China's total patent applications are several multiples of the United States at this time. They do a tremendous outreach effort, and they do a lot of support to their own companies in areas that are highly competitive with the United States. For example, in Research Triangle Park, you have a thriving biotech industry, and I've heard Chinese patent commissioners and deputy commissioners talk about what they have to do for their generic companies so that they can compete better with innovative companies. China has a non-transparent and opaque administrative enforcement system, which has about 50,000 patent infringement cases per year. It heard about 24 patent linkage cases in the past year or so. That was under the Phase 1 agreement, a system of linking marketing rights with non-infringement of patents. Those cases are non-transparent. We do not know what is happening in those cases. And the 50,000 or so administrative cases suffer from the same problem. So the system is getting stronger. It's also much more tightly geared to larger Chinese companies. Xi Jinping gave an important speech about 2 years ago where he said he wanted to improve the quality of Chinese patents. And we've seen a big increase in at least the filings by large companies, a withdrawal of subsidies, which were a big distortion. But overall, this seems to be having an effect of migrating a system that at one time was fairly tightly tied to small businesses in China to one that is really dealing more closely with state-owned enterprises and large Chinese private companies. This, to me, is a looming, legitimate competitive threat. It could also have its illegitimate side, but it is a looming threat as China becomes more sophisticated. You also see judges issuing more sophisticated and lengthy opinions, engaged in the kind of anti-suit injunctions that my colleague just spoke about, picking up on sophisticated tools that, if applied to foreign companies, could be very harmful.
Thank you for your indulgence, Mr. Chairman. I yield back.
I thank the gentlelady. We now go to the gentleman from California, Mr. Kiley.
Thank you, Mr. Chair. Mr. Evanina, I wanted to take a moment to reiterate a few aspects of your testimony. You say that Xi Jinping's goal is to be the geopolitical, military, and economic leader in the world. You say that Xi, along with the Chinese Ministry of State Security, People's Liberation Army, and the United Front Work Department drive a comprehensive and whole-of-country approach to their efforts to invest, leverage, infiltrate, influence, and steal from every corner of the U.S. This is a generational battle for Xi and the CCP. It drives their every decision. You go on to say that this is an existential threat to America and that the strategy of the Chinese Communist Party begins with U.S. intellectual property and trade secrets theft. We also have statistics in the record today about how, according to the Department of Justice, approximately 80% of all economic espionage cases prosecuted by DOJ involve theft of trade secrets by the Chinese government or its instrumentalities or agents, and approximately 60% of all trade secret misappropriation cases brought in the U.S. have a nexus to China. Now, the Biden administration, about a year ago, decided to end the China Initiative. This is a headline, February 23rd, 2022, from NPR. The Justice Department is ending its controversial China Initiative. And the head of the National Security Division was Assistant Attorney General Matthew Olsen, who said, "While I remain focused on the evolving significant threat that the government of China poses, I have concluded that this initiative is not the right approach." Instead, the article goes on, he said, the current threat landscape demands a broader approach. And Olsen also added that, that I do believe that the China Initiative was driven by genuine national security concerns, but I am also mindful that the department must maintain the trust of the people whom we serve. So you say this is simply a change in nomenclature as opposed to a substantive change in the initiative. But what effect do you think the comments of the Assistant Attorney General and the decision to say we're ending this program have in terms of the message we're sending to the rest of the world about how much we tolerate intellectual property theft from China?
Congressman, thanks for the question. I'm not sure about the intent of the narrative of the Department of Justice statement on their impact of the China Initiative, but I can tell you that the initiative has not ended. They may have changed it, but I think right now, more than ever, you're going to see an uptick in cases and investigations. But also, despite that effort, the American companies are reporting nefarious activity more now than they ever did. And I would say that to your numbers, and I think we have to also remember on data theft is an issue here with the Communist Party of China, and that was also inclusive of the initiative. And we're looking at 80% of all Americans have had all their data stolen by the Communist Party of China. The other 20%, just some of their data. So when you include intellectual property and data theft, it's unequivocal existential threat that the Communist Party of China poses against the United States.
Thanks very much. And Mr. Cohen, you quote a study in your testimony about how China's global lead extends to 37 out of 44 technologies right now when it comes to innovation in a number of crucial technology fields. And you also discuss how we need to have a better understanding on how the declining scope of patent-eligible subject matter has affected U.S. competitiveness with other countries, including China. So it seems there's a few aspects of the problem we've been talking about. There's the Chinese theft, the theft of U.S. intellectual property by the Chinese Communist Party and its agents. There is the growing capacity of China to produce its own intellectual property. And then there's perhaps, in some ways, our declining capacity in the United States to keep pace. So I just wanted to give you a moment to discuss the extent to which that third facet of the problem is something that we could address, and what are some concrete steps to do so.
Great question again. Thank you for that. This question, I think, relates to declining STEM education in the United States, reliance on foreign talented students coming here rather than our own people to be educated in STEM-related disciplines. I think also in terms of competitiveness with China, I think the lack of Chinese-educated scientists, Chinese language-educated scientists and diplomats also contributed to a lack of deep understanding of the Chinese competitive threat, if you will. And I'm always amazed when we talk about Chinese industrial policy that people always refer back to Made in China 2025. It's now 2023. 2 years from now, that's gone. Along the way, we've had hundreds, perhaps thousands, of 5-year industrial policies out of China at a national level, a local level, a ministerial level, at a trade association level. Actually, it's a rich trove of information, if you will, that could be used to determine the kinds of competitive threats that the U.S. government and U.S. industry should consider when it invests and when it makes strategic decisions about American competitiveness. So we really need both sides of the equation, I think. We need more scientists and engineers, more scientific talent, and to be attractive to other countries, citizens to come here to study, to work, and to build up new enterprises. And we also need better technology management and better understanding of the competitive threats in order to manage our relationship with China.
I thank the gentleman's time has expired. We now go to the other gentleman from California, Mr. Schiff.
We have a lot of gentlemen from California on this subcommittee. That's a good thing.
Must be something about California's position in IP that drives us all here.
There is indeed, and as the chairman knows, I've had a long history on this issue because I represent so many people in the creative industries and formed a bipartisan bicameral caucus to combat intellectual property theft. Mr. Cohen, one frustration I've had, deep frustration with the administration, is we still don't have an intellectual property enforcement coordinator. Why is this taking so long? Why is this a problem? I don't understand the delay.
I wish I had the answer. I feel like we desperately need that IPEC role in place. I think the IPEC plays a critical role in coordinating the alphabet soup of U.S. government agencies involved in intellectual property. I think the average American is unaware of how extensive that alphabet soup is. It's the USPTO, it's DOJ, it's DHS, it's USTR, it's the Copyright Office, it's any number of agencies that have an interest in intellectual property protection and enforcement, and it's, of course, its relations with state and local governments as well. And in order to make that system work, we need a coordinator in the White House. I would also like to see, frankly, a deputy PTO director in charge of international affairs, because I think it's very hard to be running an office of 10,000 plus people and also to consider the international implications of the issues that we're talking about today.
And do we see the impact of not having these positions filled, or is it a separate problem that in agreements like the Indo-Pacific Economic Framework, there aren't stronger IP provisions?
Well, I think this administration has taken a light approach to intellectual property, particularly in an international context. The free trade agreements or texts that are being discussed have very little of IP in them. If you contrast that to the RCEP agreement that China shepherded through, it's the largest free trade agreement in the world, I think, right now. Has about 30% of global trade under its roof. There is an IP provision. There is an IP chapter in there. It's IP light, but it's also a broad agreement. So I don't know why the U.S. cannot be promoting intellectual property, which at the end of the day is, I think, good for the companies that we're negotiating with as well. And of course, it's critical for industries that have a high degree of vulnerability in the digital environment, like motion pictures, music, and software.
And just to follow up on a couple of questions my colleagues asked about non-disclosure agreements, about China's abuse of the patent system, surreptitious funding of patent trolls. Does it make sense to approach it not on a country-specific basis, that is, single out? You can have non-compete clauses vis-a-vis China. Does it make more sense to try to identify those who are abusing the patent system or who are stealing intellectual property and have a standard where if you're a vexatious litigant as a foreign country or some metric by which we can provide greater protection rather than singling out a particular country?
Well, I'm concerned that if we start singling out particular countries, we weaken the framework that this country has invested in for so many years regarding most favored nation treatment in the TRIPS agreement and in Berne and Paris and other treaties that are basically the bedrock of the international system. I think we should be singling out practices, not individuals certainly, and not countries if we can. We have had successful, if you will, application of export controls against Fujian Jinhua, which was accused of stealing trade secrets from Micron. That was about 3 or 4 years back. And of course, there's been recent legislation in Congress to sanction foreign persons who steal U.S. intellectual property. So there are alternative mechanisms through export controls in particular, visa denials and the like, that can be used if a system is completely intractable. I'm a little concerned about the legislation passed last December because I think we need to make a showing that you cannot protect your trade secrets in a given country, let's say China, and therefore we have to impose an export control measure denying access to U.S. capital and the like.
See if I can sneak in one last question here before the clock runs out on me. Trying to put some limits, for example, on the screens that American films can be exhibited on, et cetera. We have no limit on Chinese films exhibited here. How do we better use our market strength to command fair treatment in other countries like China without giving them all the benefits to operate domestically and having none of those advantages when we operate there?
Yeah, the 34 film quota has been a thorn in the side of Hollywood for quite a long time. And one answer, it's not a complete answer by any means, is...
And a short one would be appreciated.
Yeah, okay. The vacuum is filled by piracy. So we have to do something about the piratical content that's out there in order to drive legitimate content. And beyond that, this is something where China is within its rights to deny market access under its TRIPS and WTO accession. So our biggest tool right now is, I think, IP-related.
Thank you, Mr. Chairman.
Thank you. We now go to the gentlelady from Florida for 5 minutes.
Thank you, Mr. Chairman, for holding today's hearing on this critical issue. These witnesses make clear the CCP is engaged in an insidious and expansive campaign to target U.S. economic interests and our national security through litigation and exploitation of U.S. policy. The CCP is capitalizing on weak non-compete laws in states like California, filing excessive invalid patents, and committing criminal espionage. In my home district, Chinese nationals and a Navy officer were indicted for attempting to steal a Navy vessel and take it to China. Had they succeeded, this one act would have provided the CCP with valuable information about our technology, our military, and our strategic defenses. It is an example of the significance of this type of investigation and this type of work by our federal law enforcement partners. The United States must do more to defend our country, to respect invention, and to encourage innovation. We must protect research, data, and intellectual property from theft, misuse, and infringement. And where we see unlawful conduct, we must commit ourselves to swift and strong enforcement. I thank our witnesses for their presence and their testimony today, which helps us shine a light on this threat to our economic strength and our national security. With that, Mr. Evanina, I would like to return to your testimony and the discussion related to the China initiative that you were offering earlier. And specifically, I would like to visit the subject of our institutions of higher learning and our universities. Would you please speak to, we know that China has been attempting now very aggressively to infiltrate some of our universities, to steal intellectual property there, and to benefit from the innovation and research that is occurring on American university campuses. Would you please speak to what the China initiative was doing in that regard and what we need to be doing going forward to protect those institutions?
Thanks for the question, Congresswoman. I think when you look at the question you pose on academic institutions, it's the bedrock for what makes America the best country ever. And part of that is the collaborative mindset and ideology for a university setting. Also provides the most vulnerability specifically to the Communist Party of China, to penetrate that, not only with students, with professors, with deans, to be able to take that early access ideation all the way up to the patent perspective in a free and open environment. I've had the opportunity to speak to over 140 university presidents the last 5 years about this issue. It's a dire issue, but it's really complicated in facts. And I think, from my perspective, when the FBI or law enforcement comes on the campus to investigate, it's too late. The information's already gone. I think we have to do two things here. We have to look at that ideation process and have a compliance structure that's not only put in place by academics, but also supervised and governed from a compliance perspective, either by the states or U.S. Congress. Secondarily, for those Chinese students who come here every year to study, which is well over 300,000 per year, we're only really worried about a handful of postgraduate STEM programs. I think if we, as the United States and the Congress, gave every single student who came from China a cell phone, a mobile phone they could use that provides some independence from the Communist Party regime, I think that'll go a long way with not only winning the hearts and minds of those students, but also putting a perspective of compliance in place at the university.
And a moment ago, you mentioned a particular concern about data theft. Tell me how data theft plays into the overall threat we're facing from this adversary.
Sure. Well, I think data is the new global commodity. And I think the Chinese Communist Party got to that fact way before we did. And I think when we look back over the last 5 to 7 years, the amount of data theft that occurred from cyber breaches and insiders really connotates the direction for what Xi Jinping wants to not only drive their AI, but their targeted American citizens, global citizens around the world. You can only have the best AI and quantum computing if you have the most data to run it against. And that's been part of the strategic plan for the Communist Party of China, is to acquire the global repository of data through theft and otherwise.
And then, Mr. Cohen, a follow-up question for you. A moment ago, you referenced the lack of transparency in the Chinese court system. And I know you made reference also to, at times, the failure to report decisions and how that can be an important aspect of us understanding the nature of the threat that we face in the arena of the courts. Would you please elaborate on that lack of transparency and why it is important to protect American interests?
I feel like I should be back at school teaching. This is a long lecture in my Chinese IP class. About 2014, China started making its court decisions available online. Probably the biggest development in rule of law internationally of the past decade. I checked a few days ago, there were 1.4 billion visits to that webpage, 131 million documents on that site. So there's a lot of content there. We've lit the proverbial candle in the dark room in terms of knowing something of how Chinese courts work, how IP decisions are made, but it's hardly fully illuminated. And what is not illuminated are the cases that are hidden from us. And these cases are not published for a variety of reasons. Many of them are small or inconsequential. Many contain confidential information, particularly the trade secret cases, and China doesn't publish cases having confidential information. That's part of the reason we know so little about the trade secret environment in China. In fact, of the published cases, about 600 of them over the past several years, only 5 of them involve foreigners. 5. Were there more than that? Possibly, but it's an extremely small cohort to make a decision. So encouraging full transparency, and the court system, by the way, is light years ahead of the administrative system, which has a docket nearly as big. China had 600,000 civil IP cases last year. 600, that is a huge number, and about 12,000 criminal cases. The lack of insight into how those cases function haunts us in so many ways. Are we treated fairly? Are the courts handling things, technical matters, in an appropriate manner? How much bias is there? What about anti-suit injunctions or other remedies that China issues? I mentioned a company called...
Mr. Cohen, I'm going to have to ask you to put the rest in for the record.
Okay, but in any event, this is a critical issue to understand the environment. Thank you.
Thank you. And this is the reason this is the first of several hearings on this subject. With that, we go to the gentleman from South Carolina, Mr. Fry.
Thank you, Mr. Chairman. I really appreciate you having this hearing today. To the panel, thank you for being here. The Chinese government has a core mission to achieve technological parity. We've talked about that today, and eventual superiority over the U.S. To this end, Chinese entities backed by the Chinese government are acquiring massive amounts of patents, IP rights, and trademarks that prove to be obstacles and potential threats to our own citizens and industries. In 2015, the Chinese government announced, as we talked today, its Made in China initiative, which identified key technological areas and industries China intends to target. This includes, of course, aerospace, next generation information technology, advanced rail systems, and biotech. Professor Cohen, as China moves into the next phase in its development after its Made in China 2025 initiative, what do you anticipate the Chinese government will do in its strategic plan to target the U.S. in terms of our IP and technology?
Well, China is very much aware that we're in a competitive situation, our two countries, and I think we're going to see increasing targeting of industries that China views as critical to its own national economic development or security, and particularly in areas where the U.S. is denying access. I think semiconductors is probably foremost among them, and we could see in the constitution of the party Politburo and other leading organizations where we have a higher cohort of STEM-educated party members, as well as a higher cohort actually of semiconductor-oriented STEM-educated officials. So it's very clear that that is way up there. I think biotech is some of the other areas we mentioned, particularly in AI, security applications involving AI, and anything involving national defense, including national defense patenting.
Thank you. And finally, this Mr. Evanina and Professor Cohen, considering recent government findings regarding the risks of technology commercialized by Huawei and TikTok, what do you think are the dangers posed by Chinese technology being incorporated into international technical standards like 5G, 6G, Wi-Fi, et cetera? We'll start with you, Mr. Evanina.
Thank you, Congressman. I think the threats are significant, and the U.S. government, intelligence apparatuses, and law enforcement need to do a much more effective job at educating the American public of why that matters. For instance, the current war on TikTok, the issue, the conversation, the dialogue, it is not a political issue. This is a data-driven issue of the nefarious, not only capabilities, but intent of the Communist Party to get into that software and have access to your entire phone. We just do not educate well enough what that threat is. With Huawei, Huawei got, again, the Chinese Communist Party strategically, more than a decade ago, saw vulnerability in our inability to communicate, especially in the rural markets, for telecommunications, and they took advantage of that. And those systems they put in place had also intelligence apparatuses combined to a legitimate business perspective. So I think when you look at how sophisticated they are with utilizing legitimate business enterprises as intelligence apparatus, we just need to educate more effectively what that looks like and make an educated consumer, whether it be a state, locality, or a business person, what the risks are.
Thank you. Professor Cohen?
Yeah, I think social media and apps on your phone are one risk. I think IoT in particular is another huge risk that this country has to deal with, where our data will go back to the provider of the equipment, who in most cases is going to be based in China. So this is really a matter of evaluating the backdoor risks that are posed, and I think we do need to do a better job of that task. Thank you.
Thank you. Mr. Chairman, I yield back.
I thank the gentleman. And you know what? That means it's my turn. I yield myself a little bit of time here. We'll start with Professor Duan. Now, Huawei cannot produce products inside the United States, but they are second only to IBM for the most patents applied for every year or received. Would you give us a contrast of the quality of that amazing quantity and where some of those end up?
Yeah, so there are a couple of things that are going on here. The first is that there is a strategy across China, and particularly with companies like Huawei, to obtain large quantities of patents. Now, one way to get a lot of patents is to just file as many things as you can and see what sticks to the wall. And so we've had a number of studies looking primarily at China's international portfolio that have identified serious quality concerns with the patents that China is seeking.
And is that because when you're a large company that applies for a lot, you tend to have a team of lawyers that are just really good at squeezing through patents by whatever means you need to have them survive?
It's that, and it's also just a volume game, right? The more that you can file, the more words that you can put down onto the page, the more chances you have of getting through. But that's not to say that China's just sort of, or that Huawei is just filing sort of across the board. They're focusing on particular strategic areas, and we just had a conversation about technical standards in communications. China and Huawei particularly are leading in filing of applications that are required by the 5G and other technical standards. They've also taken other measures to be dominant in those standard-setting processes. What that means is that those patents now must be used by any device that implements those technologies, such as 5G. These are not ordinary patents anymore where somebody can say, okay, so we're worried about this patent, we'll figure out a way to work around them. They're necessary in order to work with the infrastructure. That gives China a substantial leg up in enforcement when it comes to those sorts of technologies. And so the way that companies have tried to deal with, or the way that these standards organizations have tried to deal with, sorry, go ahead.
Even my time can be limited. Let me just sort of narrow the scope here. My understanding is Huawei also licenses out their patents, in many cases patents they're not using in the United States, license them out to venture organizations. Can you opine on that if you know?
They do, and I think that I've seen a fair amount of evidence of transfers of patents, especially these sorts of standard essential patents, to a variety of different entities. Now, one problem is that, as Mr. Cohen alluded to, we don't know a lot about what's going on. We don't have the sort of transparency measures that let us know what happens to the finances of patents or patent litigation. And I think that one thing that we can really try to build out is building out that transparency in patent ownership and patent litigation so we can see to the extent that Chinese-owned patents or that Chinese entities are controlling patent litigation. I think that that's going to be an important thing to look forward to.
Mr. Cohen, we've given you a lot of questions on trade secrets, but it's fair to say that companies like Lam and Advanced Materials are global leaders, two of them, but even when they have trade secrets, even when they produce unique product, their customers sometimes have trade secrets beyond that. Taiwan Semiconductors makes chips using their equipment that other people using their equipment currently cannot. Just briefly, Taiwan's non-compete and secrecy laws as contrasted with us, are theirs tighter than California?
Taiwan, like mainland China, permits non-compete agreements. As with many other European countries, they're limited in duration, and you have to provide some form of reasonable compensation for the duration. So that limits the application of non-compete agreements to highly skilled, compensated employees where it's really important.
But it's fair to say that we cannot compete against those countries if they have that kind of non-compete that are essentially protecting their trade secrets and their developments, and we don't.
That's correct.
Okay, Mr. Greer, one of the questions that I have for today, oddly enough, is the TRIPS waiver that the president did related to COVID-19. One, would you, in your old boss, have recommended any sort of a waiver? And if so, would you have limited the waiver to not to the patents themselves, but to production of the product? Meaning, you can produce the product, but you cannot have, if you will, access to the technology going forward.
Well, sir, the waiver was first requested in 2020 and was presented to Ambassador Lighthizer, who declined to endorse that.
So that part of the answer is yes.
That's right. So that's that. The TRIPS agreement already has space in it and was amended once already to provide clarity on what we call compulsory licensing, right? If you have a situation where voluntary licensing just doesn't work out and you can't come to terms, it provides for compulsory licensing. And so this idea that you're going to have some additional TRIPS waiver is not only duplicative to some degree of what's in the TRIPS agreement, but also undermines international IP rights going forward at a time when the WTO is already on thin ice.
Now, one quick question for law, and anyone can answer, but Mr. Greer, you might be the best. Under international law, if we refuse to supply life-saving product, including a vaccine, to a country, they have an absolute right to source it themselves or to essentially invalidate the patent and produce it. Isn't that correct?
That's exactly right. World Trade Organization agreements, they have exclusions for public health and safety. TRIPS agreement itself has a provision where if you can't come to terms in getting what you need, Article 31 and 31B allows you to do that kind of thing.
So there was no denial.
Exactly right, yeah.
Okay, and I'm going to take the liberty of just one quick follow-up question. Mr. Evanina, you've been very quiet for a little while, but we have touched on, but we haven't fully explored the current events that we see, balloons floating over our country, provocative acts, because it's outside our jurisdiction. But when we look at what the FBI director and others have said about the amount of theft being done and its effect, today we kept repeating the $600 billion as though money was the problem. From a standpoint of the global conflict and the ability not to economically compete, but militarily, would you close out this hearing with the, if you will, your view on what that means around the United States from a standpoint of our security with that much intellectual property being stolen every year, not in dollars, but in risks to the American people?
Thank you, Chairman. And that's going to be a long answer, but I'll keep it quick.
Well, you're going to have to make it a little short because a lot of
Yes.
people want to leave here.
I think
you're the closer.
This hearing on intellectual property, very minute aspect of the threat posed by the Communist Party of China. I think your question, the threat to the homeland, starts there, but also looks at the surveillance and penetration of our critical infrastructure, our gas, natural oil pipelines, our electrical grids, our ports, our maritime facilities. The preamble to any kind of future conflict, the Chinese Communist Party has spent a decade preparing for that battlefield for us, not only in a corporate perspective, but a military perspective. It starts with energy, power, and financial services. So I think when you look at what the Chinese Communist Party looks at us, is be able to pre-conflict, during conflict, prepare the battlefield so we cannot act in that battlefield. And that starts with the critical infrastructure.
Thank you. And as much as I would like a second round, I'm going to have to ask all of you, would you be willing to take questions for the record? Since I have all yeses, all questions submitted will be left open for 5 days and a reasonable amount of time for the answers so we can have a complete record. As I said in the introduction, this is the first. It is clear that we only really touched on many of the areas we have to work on. I will say that when we look at intellectual property, I deliberately closed out on the national security risk because I believe that this committee has an obligation to look at IP protection, including those that might affect trade secrets and the like, as being part of our national security. And for that reason, I wanted to close on that, and I appreciate everyone's indulgence. And we stand adjourned. Yeah, it was a good start. Yeah. And they want more.